All right, let's get right into it. When you really stop and think about the law in Australia, where does it all actually come from? It's not just one single source. It's a really dynamic system, and it's built on two massive foundational pillars. And today, we're going to break them both down.
So let's start with that big question. It seems simple, right? But the answer, well, it reveals this fascinating power balance that's right at the heart of our democracy. It's a story about the people we elect, about independent judges, and about a foundational rulebook that kind of holds the whole thing together.
Every strong system needs a solid blueprint, a master plan. And for Australia's legal system, that blueprint is one of the most important documents in our nation's history. And that blueprint is, of course, the Australian Constitution. Just think of it as the ultimate source of legal authority. It sets up all the key players. You've got the Parliament, who makes the laws, the executive, that's the government of the day, who puts those laws into action, and then the judiciary, our courts, who get to interpret them. Now, this separation of powers is absolutely crucial. See, while the government is drawn from the Parliament, the judiciary is kept strictly separate, and for a really good reason. This independence is what lets our courts act as these impartial umpires, making sure everyone, and I mean everyone, including the government itself, plays by the rules in the Constitution without any political pressure.
Okay, so with that foundation set, let's look at our first pillar. These are the laws made directly by the people we send to Parliament. This is the kind of law you probably hear about most often.
We call this statute law. These are the formal, written acts of Parliament, passed by our elected reps, and they cover pretty much everything, from road rules and taxes to healthcare and criminal offenses. If Parliament decides society needs a new rule, it does it by creating a statute. Simple as that. So how does that happen? Well, it starts life as a bill, which is really just a draft law. That bill then gets debated and scrutinized, and it has to be passed by both houses of Parliament, the House of Representatives and the Senate. Once it makes it through that whole gauntlet, it gets what's called assent and officially becomes an act. Now for our second pillar. This one's different. It's not written down in a single rulebook by politicians. Instead, it has evolved over hundreds of years through the decisions of judges in actual courtrooms. This is what we call the common law, or sometimes judge-made law. It grows organically out of the real-life disputes that come before the courts. So when a judge makes a decision in a new or tricky case, that decision can set a new rule or a precedent that other courts are then expected to follow in the future. So how does a system like that stay consistent? Well, it's all governed by something called the doctrine of precedent. You can kind of picture it like a pyramid. It just means that lower courts have to follow the legal principles that were set down in earlier decisions by higher courts. Right at the very top of that pyramid is the High Court of Australia. Its decisions are the final word, and they flow all the way down, binding every single other court in the country. This is what makes sure the common law is applied the same way everywhere. Okay, so we've got Parliament making laws proactively, and we've got courts developing laws reactively through individual cases. So what happens when these two powerful forces meet? This right here is where the real balancing act of our legal system comes into play. This really highlights the difference, doesn't it? On one side, you've got Parliament, which can be proactive. It can create these big, sweeping new laws that affect everyone. But on the other side, you have the courts, which are reactive. They can only make law based on the specific case in front of them, which means the common law tends to evolve much more slowly, just one case at a time. The crucial point here is the relationship between a law passed by Parliament and those common law rights that have existed for centuries. See, courts don't just blindly apply statutes. They interpret them through a really important lens called the principle of legality. And this famous quote from the High Court just sums it up perfectly. What it means is that the courts start with an assumption. They assume Parliament does not intend to override our fundamental common law rights, things like freedom of speech or property rights, unless Parliament says so in the clearest, most unambiguous language possible. It acts like a safety net, really. It makes Parliament stop and think very, very carefully before it tries to limit our basic freedoms. So this balancing act between Parliament and the courts is constantly being tested. I mean, our legal system has its roots in English history, but it doesn't operate in a vacuum. It has to constantly adapt to modern and uniquely Australian challenges. And one of the biggest challenges is figuring out how to recognize the world's oldest living legal traditions within Australia's modern legal framework. So how does our system account for Indigenous customary law? Well, the approach so far hasn't been to create a whole separate parallel legal system. Instead, it's about adapting procedures within the one we already have. A great example of this is circle sentencing in New South Wales, where Aboriginal elders are actually brought into the sentencing process for Indigenous offenders. But the core challenge is always to make sure this recognition is consistent with universal human rights and to carefully balance those collective cultural traditions with the fundamental rights of individuals. It's a complex, ongoing conversation, for sure.
So, as we start to pull all these threads together, what we see is a legal system that's not defined by a single authority, but by this constant dynamic balance of power. At the end of the day, our law is a continuous conversation. Parliament speaks by passing statutes. The courts respond by interpreting those statutes and developing the common law. And the whole thing stands on that supreme foundation of the Constitution. It's these two pillars, working together, that create the legal landscape we all live in. And that leaves us with one final, really thought-provoking question that gets to the very heart of this entire structure. In this ongoing dialogue about our laws and our fundamental freedoms, who do you think should have the ultimate say? The politicians we elect, or the independent judges appointed to our courts?